Thank you. Good afternoon. Welcome to Division 5 of the Colorado Court of Appeals. We have a couple of cases on our 1:30 docket, and we're happy to welcome our retired senior judge, Judge Henry Nieto, and we have Judge Jerry Jones here as well. So let's go over a couple of things. Counsel should have received our written instructions for oral argument. If there are any questions about those, now is the time to ask them. Hearing none, we'll go ahead and proceed. I just would ask everybody that is in the courtroom to please turn off any device that you have that might receive a text or an email, because it might interfere with our live streaming equipment. We are live streaming on the web, and your arguments are being recorded. They can be listened to afterwards on the court's website. And because that's the case, please keep in mind that if you have any confidential information that you don't want broadcast to the world at large, keep that in mind as you make your arguments. All right? That being said, let's proceed with arguments in our first case, Colorado Real Estate versus Vizzi, and I apologize if I've mispronounced his name. Please proceed.
And, Your Honor, if I could just respectfully ask 3 minutes for rebuttal argument, just to reserve that.
Fine, and you need to keep track of your time, though, counsel.
I will, Your Honor. Thank
Sure.
you very much. May it please the court, my name's Nathan Osborne, registration number 38951. I am here on behalf of Mr. Vizzi, the appellant in this case. This case originally concerned the Real Estate Commission's opposition to Mr. Vizzi's kind of unique business practice. He was offering flat fee limited services to members of the public. Basically what that was he would go and charge people, it was pretty cheap, and then they would ask him to do things that maybe not a typical real estate broker would do. For example, he would just put the property into the multiple listing service so buyer's agents could find the property. Our case was started with an anonymous call. This isn't a situation where there were members of the public harm or consumers filing grievances against Mr. Vizzi. Eventually, trial in this matter was held in November of 2016. We were in front of Judge Light. Judge Light found some technical violations of the Part 8 is what they refer to it. It's the 1261-800 series. Found him not guilty of some charges, and then recommended a pretty favorable sanction. She required that he take 12 hours of classes, fined him a couple $1,000s, and then specifically recommended that there would be no public censure on his record. After the initial decision came down, we filed written exceptions arguing a couple points of law that we'll talk about today. The commission just filed a response to our written exceptions. They didn't file their own written exceptions. Their response said, and it's on page 15, that they were asking for the commission to adopt the ALJ's order. After that, the commission requested that we attend an oral argument. At the oral argument, there was no mention of public censure. We did not know that that was even an issue. A couple months later, the agency handed down its final order, and of course, a public censure was ordered. 5 issues today we have raised on appeal, and I'll go through them here quickly because I know I don't have much time. The first issue is whether the commission exceeded its statutory authority by increasing the punishment, by adding the public censure, and whether that violated due process. The statute that's applicable to this situation is 24-4105. That talks about what you do if you want to appeal an initial decision. And what that statute says is you have 30 days to file written exceptions. And then there is a section of that statute that says the agency on its own motion can also appeal the initial decision. There is also a commission rule K2 that's cited in Ms. Powell's papers that discusses the right of the agency to file its own motion. What the commission is saying here is that it did in fact file a motion through a letter that was sent to us, which is part of the record. The letter, or at least my reading of the letter, was it set forth a number of deadlines, told us that we had a right to appeal, but the letter to me wasn't a motion. The practical impact of this letter was that we were unaware that the issue of increasing the punishment was at issue when we attended the oral argument. And as I mentioned previously, this was especially true because the commission responded to our written exceptions and asked that the ALJ's order be adopted by the commission. One case, and it's just purely coincidence, but I know Judge Jones and Judge Nieto, you were both on this case, but it's the Winterhawk Outfitters case. That case also involved a letter and whether the letter was a motion. And there was a quote from that case that I thought was very on point here, where it talks about numerous statutes referred to the filing of a motion. In our view, overly broad construction of the statute and its dilution of the term motion would have far-reaching and undesirable impacts on the administrative procedure. And I would submit that's exactly what occurred here. Our second issue is whether the imposition of public censure is arbitrary and capricious. I'm sorry, Your Honor, go ahead.
Before you moved on, I want to ask you about the Hannigan case.
Yes.
Because that case seemed to approve of exactly what happened in this case. And that's a Colorado Supreme Court case. I think we have to follow it. And your reply brief didn't address it at all. So I'm wondering, how do you distinguish Hannigan?
So Hannigan, they increased to add the public censure. That involved the case where she didn't take the required classes. To me, my reading of that case dealt with whether the public censure was, so kind of our issue too, whether that was appropriate in light of the circumstances of the case. I didn't see the actual procedural posture in there. I'm not really certain if a motion was filed or if the agency adopted its own review. I didn't see that issue addressed. I felt the issue addressed in that case was more dealing with my issue too, whether the punishment was arbitrary and unreasonable.
Well, what I'm struggling with is that in that case, as here, the original penalty imposed did not include the public censure,
Correct.
but the commission added that, just as here. I don't think that turned on whether some motion had been made or anything like that. I think they just turned on the statute, which says that the commission can modify the penalty.
Well, and I would say a distinguishing factor here is the response to the written exception asked for adoption of the agency order, which included no public censure. So when I went into the oral argument.
But how does that bind the commission if the commission has the authority to modify the discipline?
Well, the commission, they were speaking through the AG's office when they responded to our written exceptions. So to the extent that binds them, it was a paperwork filed on behalf of the commission saying their request at the hearing was going to be that there was an adoption of the initial decision. And it was not addressed at the hearing either, Your Honor.
But the Supreme Court in Hannigan said, as long as the record as a whole provides sufficient evidence that the penalty is not manifestly excessive in relation to the misconduct and the public need, the penalty will be upheld.
Correct, Your Honor.
And why doesn't that apply here?
Well, I think that applies to my issue too. I do think the standard of review is pretty deferential to the commission when it comes to whether a public censure is appropriate. I do think that we have Rule K and we do have the statute, and to me, we should be following these rules if their intent is to, they could have easily filed a motion saying, hey, we're thinking about increasing the punishment. I think the procedure, that's what's supposed to happen here. At least that would be my reading of the statute and the Rule K2. And that wasn't done here. The only other point I'd make on issue 2, which is just what you were referring to, Your Honor, about whether it was arbitrary or capricious. The transcript of the actual deliberation, there's a lot of discussion about sending a message to the public. I know for a fact, just sitting through the trial and just my experience with this case for the last few years, that's exactly what was going on here. They want to make sure other people aren't conducting limited services or providing limited services. The ALJ's initial decision, they have very favorable language about Mr. Vizzi in there, about how he was credible, he was honest, he wasn't trying to lie, cheat, or steal, and that she didn't feel a public censure was appropriate for that purpose. So I know there was evidence in Hannigan that they were doing the same thing to everyone similarly situated, and I don't think that's what was occurring here, because there was evidence at trial that other people are doing the same thing as Mr. Vizzi.
Was this the first one to go to hearing?
As far as I can't say that with 100% degree of certainty, Your Honor. I don't know. The other issue I'd like to touch briefly on is just the statutory interpretation, which is a fascinating issue. The Part 8, the 1261-808 and 1261-807. 1261-808 talks about the rules for a transaction broker. The word shall's in there, the briefing discusses that. There was testimony at trial from my expert, and he talked about those being the default rules, Mr. Levine, and that the reason that statute was in place was there were people in small towns having oral agreements, and that this statute provided notice to the public and to transaction brokers about what their duties were when there was no written agreement. If you go through 808, it's my opinion 808-283 then modifies 807, and it says that a transaction broker is, he can undertake obligations or responsibilities in addition to or different from those set forth in 1261-807. I believe that this is, you go through the canons of statutory interpretation, you look to the plain meaning of the words. We have in addition to and different from. The word different, if you go to the dictionary, means partly or totally unlike in nature. We use that term in mathematics, which can mean the difference, subtracting from one another. And to me, the disjunctive word of or means both words have a meaning. Different from doesn't mean in addition to.
Counsel, how do you respond to their argument that that second statute deals with disclosures and not with duties?
And that's an interesting argument because it is, the heading is disclosures. If you look at the preceding section, 2A2, so 1261-808-2A2, that talks about the disclosure part of this. That doesn't require everyone to sign it. If you look at that subsection, if you go on to A3, it requires all parties to sign it. It sounds very contractual in nature to me. Disclosures don't typically have all parties signing the document. And it also makes sense from a vantage point of what a transaction broker is. We were the first state to adopt the transaction broker ideology. We're not fiduciaries, or transaction brokers are not fiduciaries. They are not agents. And it seems to me that would open up the concept of having more freedom to contract, to be able to do things like this.
So, Counsel, you're asking us to construe that statute as limiting then the mandatory duties in I can't get the number straight, but.
Yeah.
807.
807, yes.
So, but if you look at the legislative declaration at the beginning of that section, it says that they want to do this so the public will be informed of the duties and obligations of brokers. Given that's their intent in enacting this statute, how do you square your interpretation of this two-word section to virtually eliminate the mandatory nature of the duties?
And it's a good question, and we talked about this at trial. My position would be that, again, those duties are to inform the public and transaction brokers when there's not a written contract. When you have a written contract, the written contract itself notifies the consumer of what's going to happen in this transaction. In this case, we had 3 people come in, all of which were customers of Mr. Vizzi, who all said, he did exactly what we wanted. We weren't confused. There was a little confusion on one thing, but he followed the contract to a T. So I would just argue, in the non-fiduciary, non-agency role of the transaction broker, that this isn't a confusing thing for the consumers. At least it wasn't in this case.
Well, why wouldn't the different language in 808 mean separate duties of a different kind, but in addition to the requirements of 807?
Well, I just think I just go back to the plain meaning of the language. Different from means you can either have more duties or less duties, and if they've just left it at in addition to, that's clear. But by saying in different from, it has to have some meaning, and the plain meaning of different from can be more than or less, or more than or less than. I'm going to reserve the last 250.
Okay.
Thank you, Your Honor. I appreciate it.
May it please the court, my name is Natalie Powell, registration 35680, and I represent the Colorado Real Estate Commission. This court should affirm the commission's final agency order because at every step of this case, the commission followed the law. First, the commission followed the law when it determined that real estate brokers cannot contract away their mandatory statutory duties. Second, the commission followed the law when it added public censure as discipline in its final agency order. Third, the commission followed the law when it found that it did not have jurisdiction to decide whether state statutes violate federal antitrust laws. And fourth, the commission followed the law when it maintained the anonymity of the individual who notified the Division of Real Estate of Mr. Vizzi's listings. I'll try to get to each point if I have time, but at first I'm going to start with talking about brokers' mandatory statutory duties in Colorado. Many of the duties that brokers perform in today's industry, such as showing homes, holding open houses, preparing marketing brochures, those duties are negotiable. But the duties set forth in Section 1261.8072 are not negotiable because our General Assembly has stated that brokers shall have those duties. And the duties in 8072 are truly minimal and basic. They require brokers to present all offers and counteroffers, account for money they receive, keep the parties informed of a transaction, assist and advise the parties as needed, disclose known adverse material facts, comply with federal, state, and local laws, and the license law. And why does Colorado have these statutory duties? Well, the history of the state's regulation of real estate brokers helps inform on that point. In 1993, in order to clarify broker relationships to the public, the General Assembly created two types of broker relationships: single agents who have fiduciary duties and transaction brokers who are not fiduciaries but act as an intermediary in a transaction. Because transaction brokers have no fiduciary duties and no common law duties, the General Assembly defined those duties in 8072. As a result, the duties serve an important public protection purpose. And the record below shows an example of how the public is protected by requiring brokers to perform these statutory duties. In one transaction, Mr. Vizzi represented a builder who initially agreed to the limited services in Mr. Vizzi's listing contract, but later in the transaction found himself needing additional help from Mr. Vizzi to get the contracts done. Mr. Vizzi refused to help, though, without getting additional compensation, which the parties had not discussed at the beginning of the transaction. Luckily, the builder was able to get the transaction closed with the help of the buyer's agent, but it shows the example that even more sophisticated consumers might need unforeseen additional help in a transaction, and the statutory duties are there to protect consumers in that instance. So not only is Mr. Vizzi's argument contrary to the public interest, but it also defies the principles of statutory interpretation. Mr. Vizzi asked this court to ignore the word shall in 8072.
Well, there are cases that say shall sometimes means must and sometimes means may, right? The legislature has changed a lot of the statutes to take that word out and change it to must, where they've said it's mandatory, haven't they?
In other cases, Your Honor, but I think when you look at all of Part 8 and all of the language of Part 8, Mr. Vizzi's interpretation doesn't make sense, because Mr. Vizzi also asked this court to ignore another section of Part 8, Section 1261.8035, which states that the public can contract with real estate brokers only for additional duties. So brokers under both of those sections cannot reduce their duties by contract. And although Mr. Vizzi argues the commission's interpretation renders the phrase "or different from" superfluous, those words aren't superfluous under the commission's interpretation. While 8072 includes mandatory duties, other subsections of 807, such as subsection 3, 4, and 5, have potentially negotiable duties. For instance, subsection 8073 states that a broker shall not disclose certain information without the informed consent of the parties. So if a broker gets the informed consent of the parties and discloses that information, then the broker would be potentially doing something different from what is stated in 8073.
Counsel, let me ask you about this issue. The alternative rationale that 8072 relates to, not 8072, it's the 2A3 relates to disclosures and not to duties. I have a little problem with that because it talks about disclosures of duties. So it kind of begs the question, well, what are the duties? So are you defending that rationale?
Well, Your Honor, it does refer to disclosures, but I think that if you think about what the legislature could have intended, would it have intended that a broker could use disclosures to eliminate duties? And I don't think that makes sense.
Well, I don't think it's quite that. I think it's, if you have eliminated duties, you must disclose it. I don't think it's saying you have to eliminate them in the disclosure document. If you see where I'm going with that.
Okay.
Okay, that would be their position, as I
Mhm.
understand it. And so I guess I'm just not persuaded by this notion that just because it deals with disclosures, it can't have any bearing upon what the duties are. I mean, the language is in there, or different from, okay? So we have to look at what those duties could be. What are those different duties?
Right. And I think even the interpretation too, though, could be that different from, again, you can modify what's set forth in 807, because 808-2A3 refers to all of 807. In some of the subsections within there, potentially under the terms of 807, a broker could do something different from what is stated there. For example, with the informed consent of the parties. But 807-2 uses the word shall, presuming that the legislature wanted to make those duties mandatory.
Okay, and you're going with 8035 as well.
Correct.
So the 2A3, when it talks about in addition to, well, that's referring back to perhaps 8035, maybe some other things. And when it says or different from, it's referring to 8073, 8074, et cetera.
Correct.
Okay.
Yep. Mr. Vizzi's interpretation would also, as the administrative law judge pointed out, lead to an absurd result in this case because it would allow brokers to avoid the duties listed in 807-2 that serve very important public protection purposes, such as the duty to disclose adverse material facts known to the broker. So the legislature would need to make significant changes to all of Part 8 in order for Mr. Vizzi's interpretation to be permitted. The commission also acted within the parameters of our State Administrative Procedures Act when it added public censure to its final agency order. Because the commission is a single board, it acts in two functions, first as a prosecutor and then in deciding the discipline as an adjudicator. Although the commission did not file exceptions in this matter as a prosecutor, the Administrative Procedures Act does not limit the commission's review of an initial decision as an adjudicator to only the issues raised in Mr. Vizzi's exceptions. Instead, once exceptions are filed by any party under the APA, the commission maintains jurisdiction to review that initial decision. And then the APA defines the scope of the commission's review under section 24.4.105, subsection 15. Subsection 15A states that the grounds of the decision shall be within the scope of the issues presented on the record. That subsection says presented on the scope of the issues presented on the record, not the scope of the issues presented on exceptions. Subsection 15B states that in conducting its review, the commission cannot set aside findings of evidentiary fact unless they're contrary to the weight of the evidence. But for the sanction, that subsection states that the commission can affirm, modify, or set aside the sanction in conformity with the facts and the law.
Do you think those sections remove any duty to give notice to the person being sanctioned as to exactly what the goals of that hearing are?
Your Honor, I think as the commission in an adjudicatory capacity in its review, the APA doesn't require it to specify what issues it's going to be reviewing. And instead, the APA sets forth the scope of what the commission can do during its
Are there due
review.
process problems with that approach?
I don't believe so, Your Honor. In this case in particular, the commission was seeking public censure from the beginning of this case. And, and notified Mr. Vizzi in its notice of charges that it was seeking public censure. So he had the opportunity to defend against public censure. And the case law states that the commission, I think it's Dixon versus the Board of Optometrists, says the commission doesn't have to give any further notice to Mr. Vizzi when it's undertaking its review of an initial decision. So I believe due process was met since he had the opportunity to defend against public censure from the beginning of this case. Not only that, but the facts in the law support the imposition of public censure in this case. The administrative law judge and the commission both found that Mr. Vizzi committed 4 violations of the license law. And not only due to the disregard of his statutory duties, but he also failed to disclose his role as a transaction broker. And they found that Mr. Vizzi acted in an incompetent or unworthy manner. And just as Judge Jones pointed out, the facts of this case are almost identical to the Hannigan case. In that case also, the licensee appealed to the commission. The administrative law judge had not imposed public censure, but the Colorado Supreme Court said the commission could substitute its judgment for that of the administrative law judge and impose public censure.
With respect only to the penalty, right?
Correct, that the commission could substitute its judgment with respect to the penalty. Sorry, is that your question?
Yes, that was my
Okay.
question. I'm sorry, I wasn't very clear.
Oh, no. The record here also shows that there was confusion, at least in that the builder transaction I mentioned, over Mr. Vizzi's business model. So although any final agency order in this matter will be a public record, public censure also provides additional notice to the public and other licensees of the facts of this case. I'll also briefly touch on the federal antitrust law issue. The commission properly found that it did not have jurisdiction to decide whether state statutes violate federal antitrust laws, but even if it did, Mr. Vizzi had not met his burden to prevail on this defense. In order for this court to find that the commission potentially violated federal antitrust laws, it has to agree with Mr. Vizzi's position that the commission is enforcing an unenforceable position statement and not state statutes. If this court upholds the commission's interpretation of Part 8, however, that the statutory duties are mandatory, then Mr. Vizzi's argument on this point is essentially moot. And his comparison of the facts of this case to the North Carolina Dental Board case falls apart.
Please explain your mootness position.
Well, essentially, he's only made the argument that that the commission is enforcing its position statement rather than the plain language of the statutes. So I don't know if moot's the right word, but it's basically there's no further argument for this court to consider. Essentially, if the court finds that the commission is enforcing the plain language of state statutes, then his analogy to the North Carolina Dental Board case falls apart. Because in that case, the dental board there, the U.S. Supreme Court noted the dental board did not have an explicit grant of statutory authority to regulate what they were trying to regulate, teeth whitening, and they were trying to regulate non-licensees. But here the commission has explicit authority from our General Assembly to discipline licensees for disregarding Part 8.
I think I understand your
Okay.
position. Thank you.
Are there any further questions?
No,
Thank you.
Your time has expired. You have 2 minutes and 50 seconds left, counsel.
All right, thank you, Your Honor. Just want to briefly hit on a few points. The 1261-8035, that's a statute that applies to all brokers, not necessarily just transaction brokers. And canons of interpretation, you go from general to specific, would be my response to that. If no one files exceptions and there's no motion, then the initial decision is adopted as the final agency order. So I think that's kind of, if we're talking about due process, that's an unfair result for us. We filed a written exception. They responded and said they just wanted to adopt the ALJ in final order. Had we done nothing, we might not be here today.
Counsel,
Yes, Your Honor.
if a supposed real estate broker is allowed to do what your client did and simply offer access to MLS, in what sense is he a real estate broker?
That was a question that we talked. You have to, you have to be, under the current statutory system, you have to declare yourself either a seller's agent, a buyer's agent, or a transaction broker if you're facilitating the purchase or sale. It's a good point, and our current statutory system doesn't deal with that issue very well. Go ahead.
Are you arguing that he's not a transaction broker?
No, he is a transaction broker. Under the current state of the law, he is.
But did he take that position
Yes.
before Judge Light, or did he
Yes.
take the position he was not?
No, he took that position before Judge Light, Your Honor. I'd also just briefly talk about the commission position statement. It was Exhibit 24 at trial. There's a lot of issues with that, and that kind of relates to the last issue. It uses the term minimum duties. That shows up nowhere in 807. The position statement doesn't discuss 808. It doesn't discuss the inconsistencies between the two statutes. And I would submit it doesn't provide much guidance. 808 applies to all of 807. I know the commission talks about just applying to certain subsections. It does not say that. The plain language does not say that. And with 50 seconds left, I'd just like to move quickly to issue 4, which is the failure to provide the contact information or the name or identity of the anonymous complaining witness. Interesting issue for you guys. We talked a lot about confidential financial documents, tax returns. Those were the standards imposed. I don't feel like that applies here. There's a criminal confidential informant rule of law. I don't think that applies here. The commission, there is no rule, there is no statute that says they can do what they're doing, and yet they're doing what they're doing. And I think it's very unfair. I represent a lot of real estate brokers, and I think it's very unfair that real estate brokers don't have a right to figure out who's complaining against their license.
Counsel, if they don't use that anonymous claim as evidence against your client, how is it unfair?
Well, we might have been able to use it, would be my response to that, to our advantage.
How?
Go ahead.
Do I have
You can
permission to
answer
ask?
his question.
One issue that I thought of, because I saw some redacted emails, was if this individual was involved in the same sort of business practice as us and had a similar confusion, would that not go to the punishment? Was he or she talking to Mr. Vizzi about it? I would have liked to have known what that person was doing in their connection to this case. Thank you, Your Honor, I appreciate it.
Thank you to both counsel for your arguments and your briefing. We appreciate them very much, and they will help us to make our decision in this case. At this point, your case will stand submitted, and a written opinion will issue in due course. We now have to take a recess for the court to be reconstituted, the panel to be reconstituted, I should say. So we'll be back in a few minutes, and thank you for your kind attention. Appeals. We've reconstituted our panel, and Chief Judge Bernard, Stephen Bernard, has taken the place where Judge Nieto was seated. Again, we have Judge Jerry Jones to my right, and I'm Diana Terry. We're very happy to have you this afternoon. Some of you, I think, were in the courtroom for our previous arguments, but some of you weren't, so I will repeat myself just a little bit. We are, I'll remind council that we are live streaming on the web. Our arguments are recorded. They can be watched later on if you so desire. And because they are being live streamed, we would ask council to be mindful of that. If there's any confidential information that you don't want to have to go out at to the world at large, keep that in mind. Also, anyone that has any sort of an electronic device that might receive a text or an email is asked to please turn those off because they can interfere with our recording equipment. Council should have received copies of our oral argument instructions, and if you have questions about them, now is the time to ask them. And hearing none, counsel for the appellant, please go ahead and proceed. And I apologize, I did not state the name of the case, but it is in the matter of the petition of ERS and for the adoption of the child IEH and concerning respondent appellant JH. Please go ahead.
May it please the court. My name is Katayun Donnelly, and I represent the appellant, the mother. To separate a child and a mother permanently is civil death penalty. It is only appropriate then that the fundamentally fair due process that has been required by the United States Supreme Court under the constitutions of the United States and Colorado be given to both. What happens in Colorado is that we have two separate statutes, two separate articles under Title 14 that allow termination of parental rights. Under Article 3, when we're dealing with dependency and neglect cases, we are abiding by the constitutional requirements. We are giving the parent and the child, both of them, the fundamentally fair due process as required by Santosky. But what happens under Article 5 is the question before the court. How is it that we have a fit parent? There are no allegations of unfitness in this case, who is now facing and actually has gone through the first layer of proceedings before the courts of the state of Colorado and whose rights have been terminated without having been given the safeguards that are required under the Constitution.
Pardon me for interrupting, Ms. Donnelly, but as I read the record, the arguments that you are making, for the most part, were not raised below. Am I correct about that?
That is correct, Your Honor.
If that's the case, and considering that this is a civil case, then shouldn't we simply say, in our opinion, that these were not preserved and we should not consider them?
No, Your Honor, for two reasons. One, that in every single case that has dealt with termination of parental rights, there has been the recognition that the requirements under the due process are similar, if not identical, to criminal proceedings. So what we are asking that this court would apply the same standards under which every single error pointed out on direct appeal is a structural error. But aside from that...
Pardon me for interrupting, but even if what you say is the case and we would consider these, do you have any case, and I haven't seen one in your brief, that says that such errors as existed in this case were structural errors?
Your Honor, if pretty much every single issue that we have raised here is an issue of first impression in this court. So I think it is fair to say that at least I am not aware of any other court, any other panel of this court or the Supreme Court of Colorado that has had addressed the issue of constitutionality of the step-parenthood adoption under the arguments that we are raising here. So the quick answer to your question is no, but more importantly, what has been recognized by other panels of this court, and most recently in the supplemental authority that we submitted, is the fact that we do afford the parents and hopefully the children in termination cases the same right to effective assistance of counsel in every step of the way. So it doesn't matter.
Pardon me, and if I may,
Of course, Your Honor.
this is a step-parent adoption case, and I don't know of any case that is in Colorado that has said that, first of all, there is, let me make sure you and I agree on this, there is no statutory right to counsel in step-parent adoption cases.
Your Honor, under Article 1, when you're dealing under Title 14, gives the discretion to the court to appoint counsel. So if you're not talking about that discretionary decision by the court that they can appoint counsel to indigent parents, I would agree to that limited description that there are no other case law that have specifically addressed the step-parenthood adoption.
Because there clearly is a mandatory right to counsel in termination cases, right?
Under the amendment, you mean?
In Article 3, right?
Exactly, yes, Your Honor.
Okay. All right, so if there is no mandatory statutory right, and understanding that your client had counsel in this case, so we're not talking about the deprivation of counsel, I am concerned about importing criminal rules to a civil case without a clear understanding of what the reason would be for that, or an overarching philosophical understanding of why that would be important.
Your Honor, I think that is a great question. Almost every single question that has been raised in this case would require a 15-minute argument. I understand why I was not given additional time, because we could have gone on for about a couple hours. But that question has been answered in XR AR 17CA2038 by another panel of this court. If the parents were accused of neglecting and abusing their children are given all the constitutional protections under the Constitution of the United States and Colorado, it would only beg the question as to why is it that my client, who has never been accused of any neglect or abuse and has been the primary caregiver, had made a voluntary, responsible choice to make sure that her child is going to be in the care of the biological father, safe and sound until she deals with the crisis in her life, has done it, has succeeded in it, has overcome all obstacles. Every single one of them could have taken down any other parent, has come back.
Counsel, but isn't abandonment a little different? I mean, the statutory scheme for abandonment by a counsel is different from the DNN structure generally. Can you address that, please?
Yes, Your Honor. Another great question that we have. Why is it that abandonment has become a separate category that somehow doesn't get afforded?
It is statutorily. The
Exactly.
legislature's told us it's different.
Yes, but perhaps legislature didn't consider the constitutional safeguards, and that is our question. That abandonment, first of all, abandonment does not apply in a case like this, because as we have pointed out, there was an agreement by the parties, adopted by the court, that specifically says, we are dealing with this crisis, we acknowledge it, she is going to go take care of that, come back,
Are you saying there
resume.
were no findings of abandonment in this case?
A clear abuse of discretion, clearly erroneous based on the court's order itself. There cannot be a finding of abandonment when the court puts the stamp of approval on an agreement that says, I am going to take care of this crisis, I will be back and I will resume my parental rights by itself.
But counsel, that agreement, okay, it only goes that far. It didn't preclude her from at least visiting the child.
Or
and spending-
making payments?
Or making payments and those sorts of things. But, and I'm not judging her, okay? But the fact remains, she didn't do those things.
No,
And
it
she
does.
could have, and the agreement didn't preclude that. But she didn't do anything.
Your Honor, going back to the fact, and I would like to talk about the facts. So in this case, hopefully we all agree that the standard by Santosky applies as the burden of proof. The burden is on the petitioner. Not only there was no evidence produced by the petitioner, the only testimony came from my client who testified as to the intent, as to the abandonment issue that she tried to contact and she was shut down every single step of the way, which required the need for expert testimony when it came to why is it that somebody who's suffering from PTSD, a war veteran who has been traumatized, what are their reactions? How do they react to possible scenarios like confrontation when they're shut down every step of the way, that I contact you, I tell you I want to see my child, and I'm shut down? What is my reaction? We didn't have that expert testimony. That is an effective assistance of counsel. We didn't have expert testimony on what is the best interest of the child. Is it additional trauma? Now we have it on supplemental record that we have two experts, one of them being the dean of psychology school at the graduate school at DU, who is willing to testify today, if allowed, as to it is additional trauma to put this child through the process of not seeing the mother who is dying, now sitting here and has been begging this court, the lower court, the upper court, to see her child. That is the only fact that came in to the record was through my client, and we had the disputed fact that does not even meet the burden of preponderance of evidence, let alone clear and convincing constitutional requirement. And as to the second part, as to the child support, again, the same thing. If this was handled in a DR case, we would be having complete calculation of what are her assets, what are her debts, what are her other obligations, what is her income,
Counsel,
what
it
is
sounds
his...
to me, pardon me, like you're asking us to amend the statute.
No,
To
Your
add
Honor.
all of these things that you're ticking off. We don't have that ability, as you know.
I'm asking you to declare the statute unconstitutional, Your Honor.
But counsel, it seems to me the premise of your argument is that everything that is in the DNN statute is required by due process.
Exactly, Your Honor.
Okay, I don't get that. I mean, due process typically requires notice, an opportunity to be heard, in this case, probably an opportunity to cross-examine, and a fair decision maker, an impartial decision maker. We have all of those in the abandonment context. There might be additional statutory requirements, but the fact that the legislature has chosen to impose those doesn't elevate them to constitutional requirements.
Your Honor, it is correct that the statute is not labeled as to where each requirement comes from. But we sure hope that the legislature had the constitutional requirements in mind when they decided to afford both the child and the parents counsel from day one at advisement, not later.
That's a good example, though. I'm not aware of a case declaring that there's a constitutional right to counsel in DNN cases.
Actually, there is one, Your Honor. Another panel of this court in RAM 2014-CA0956 applied the Aldrich factors and determined that there is a constitutional right to counsel in addition to the statutory right that we have in DNN cases. But going back to the child support part, there must, by the language of the statute, even if we were going to say that the statute is constitutional, which I do not concede, that there is a requirement that during the 12 months preceding to August of 2016, the petition was filed in August of 2016. The only facts on the record are that my client in the previous months, at least from January until April of 2016, was in a women's shelter, a veterans shelter in South Dakota, getting treated for PTSD, homeless shelter. And during that period of time, she only received the VA benefits, which were less than $600. Her VA benefit changed in April of 2016. So if you go back and just look at month by month, which was a requirement by the statute, aside from all these other issues, that there was no notice, there was no ability to redress, and I want to remind the court, the most important part of the due process requirements is the fact that under DNN, we do give every opportunity to the parent to fix the problems before we terminate. It is only and only the
But is
last
that a
resort.
constitutional requirement? To me, it's certainly a statutory requirement in the DNN context, but why would that be a constitutional requirement?
Because this is civil death penalty, Your Honor.
But counsel, in the abandonment context, the court doesn't just look backwards. You know, the court does look backwards for a long period of time, a year, okay? And then the court makes a determination whether the abandonment is likely to continue in the future.
And
Okay,
that is
so in
what-
other words, that's kind of similar to this notion of can it be fixed? And the court has to look at that, and the court made a finding in this case that it couldn't be.
without any facts that would support it.
I'm going to the due process aspect, not the clearly erroneous
Well,
aspect.
Your Honor, as you're aware, again, it was in RHN that this Colorado Supreme Court added the requirement in looking forward to the statute. If you read the language of the statute, there is nothing in it. So this is not the first time that we have been pointing out the problems with this statute. And I would like to reserve the remainder of my time.
Yes, you have 50
Thank you, Your Honor.
seconds remaining, counsel. Thank you. Please proceed.
May it please the court, my name is Maxine Labar Cross, attorney registration 40510, and I represent the appellee in this action. As we all know, this is a step-parent adoption case pursuant to 19.5.203.1D2. Now, in step-parent adoption cases, it's a statutory case, okay? So in order to ensure that the proceedings are fair, that the mother receives due process in this case, the statute mandates the requirements. Requires that the adoption is in the best interest of the child, that the natural parent has abandoned the child for a period of 1 year or more prior to the filing of the petition, or that the natural parent has failed without cause to provide reasonable support for a period of 1 year or more prior to the filing of the petition, and that the requirements must be proven by clear and convincing evidence. That's the due process, the procedure in a step-parent adoption case. Now, in a failure to pay child support
You're
context...
saying that
I'm
the
sorry.
procedure adequately addresses due process?
Correct. Now, in a failure to pay child support context, after the step-parent, okay, who's the moving party, has proven the statutory requirements, the court must then look at in the future whether there's any likelihood that the natural parent will provide child support in the future. Now, the burden is on the natural parent at that point, according to, in the matter of ERS, there's a burden shift to prove that the future payments will be paid in a consistent and regular basis in accordance with the court order regarding that child support. Now, the case of in the matter of ERS clarified the future support standard that had been set forth in RHN. And I can give you a cite on that. It's NRA RHN 710P 2nd 482. The court in this case found that the natural mother was unlikely to pay. And when courts look at the child support argument about future payments, past payments, they look at the past conduct as being a fair indicator of what the future will bring. Now, in this case, while it is true, and we concede there are times based on mother's testimony where she didn't have benefits and she didn't have a job and she was homeless. But the problem with her argument is she had VA benefits, She had VA benefits for a vast majority of the time since 2010, according to her own testimony. Maybe not all the time, but that's when they started. She had at least $500 a month. Not much money, but it is income. And she didn't contribute any of it to the child. None. Now, there's a case that is,
At certain points, she did.
at certain points, she did. She's in December of 2015 was when she made her first payment, and that was a $25 payment. The child support had been in place since 2013, since a stipulation in July of 2013. So from that point on, she knew she had a child support order. Exhibit 1 in the trial court is a Facebook message that she sent to the father telling him, I'm ready to pay my child support. What's the case number? That was in I can't recall the date, 2014, yet not a single payment was paid until December of 2015. And then she paid 2 additional payments prior to the adoption case being paid, or being filed, I'm sorry. So total, it was $125 from 2013 until August of 2016.
What are the constitutional implications of that, counsel, if you would?
The constitutional implications, I'm sorry, I don't understand the question.
All right, well, your learned opponent has raised a number of constitutional issues that aren't addressed in the statutes.
Correct.
Are there constitutional implications raised by inability to pay or not meeting obligations, et cetera, that you're prepared to address?
You know, I have researched and read a ton of cases in preparing for this. These arguments have been made before, and they have failed, because although money is not the right, or you can't deprive a child of a parent of a child just for money, okay? It's the failure to take responsibility for your child that's the problem. It's shirking your obligation as a parent. So even if your income is small, you still have an obligation to support your child. In fact, in the case of, let me find it here.
I didn't
I
mean to
can't
throw
find
you
the
off
case, but
completely off track.
there's a case where the dad, although he was incarcerated, it's a different situation, he made $1.50 a month incarcerated. And his rights were terminated because he spent that on himself. He didn't contribute anything. It wasn't very much. It wouldn't have amounted to much support. But it's the act of realizing you are a responsible parent for a child. You can't push that duty off on somebody else and expect to just step in and move on. There's burdens with the benefits of being parents. And when you fail to pay your child support and you have income, you are wanting the benefits but not accepting the burdens. In this case, there's a child support order. She didn't comply with it. She didn't make any effort to comply with it until December of 2015 when she sent a $25 payment in, and then 2 additional payments totaling $125 from 2013 through August of 2016 when this case was filed.
Counsel,
Yes.
let's assume all of the same facts as we have in this case, except that instead of a step-parent adoption, the Department of Human Services institutes a dependency neglect action.
Sure.
Okay, in that circumstance, what has to happen is that a treatment plan has to be devised. And that treatment plan in a case like this would typically involve things like mental health treatment, housing, or help with housing in terms of finding available housing, perhaps some vocational training, things like that, all of which is designed to deal with the trauma and the homelessness and the lack of income and those sorts of things. And this plan would be in place for a while, and the parent would have an opportunity to fix those things under the supervision of the department.
That is correct.
Okay, but under this statute, none of that happens.
That is correct.
Okay, even though the facts are the same and the result is termination of the relationship.
Correct.
All right, why isn't that an equal protection problem?
Because in the dependency and neglect action, the state is initiating the proceeding to
Well,
protect
I saw that
abused
argument.
children.
I saw that argument in the briefs, and it's like, why does that matter? In the end, it is still only the state that can terminate parental rights,
Sure.
whether it's a step-parent adoption or a DNN case. In the
Correct.
end, we're talking about state action to terminate parental rights, because only the state can do it.
Correct, but in a step-parent termination, the judge is the only state actor. The judge is not bringing the case.
Well, but
The judge is not prosecuting
I'm
the
not seeing the
case.
connection. Why does that matter?
Okay.
I'm not seeing that.
It matters because in a dependency and neglect case, you have the Department of Human Services who's taken a child who's dependent and neglected to protect them from the actions of the parent. There's a totally different purpose in a dependency and neglect case because the department is the state actor who's entrusted with protecting children. They have the obligation under state and federal law of providing services for a family to try to rehabilitate that family to return those children home, okay? That is their job. That is not the judge's job. The judge's job is to make rulings. In a step-parent adoption case, there is no Department of Social Services because there's no child abuse. Here, this child is with a fit, natural parent, in this case, the father, and his wife. They are raising this child. There's no allegations of abuse and neglect. There's no need for the department to get involved, to work up a treatment plan, none of those. The department's simply not involved. But the judge is there to make rulings. She's not presenting a case. She's not presenting witnesses. She is to decide based on the evidence. So that is the difference. Step-parent adoptions and dependency and neglect actions have entirely different purposes.
But aren't all those steps that I was talking about with the treatment plan, those are in recognition of Troxel, that we have to do whatever we can to try to make this relationship work. Because the first goal, the very first goal, is to have these two continue with their relationship. It is to avoid termination of the relationship. But it seems to me under this other statutory scheme, that's just not even taken into consideration.
Well, I would respectfully disagree that the entire dependency and neglect statutory scheme is a Troxel issue, because parents in dependency and neglect cases are not fit parents. They have abused or neglected their kids. There's an adjudication of that nature, okay? Troxel involves a custody case, number one. Okay, step-parent adoption is not a custody case. And it's a fit parent presumption in favor of third parties. So as I understand Mother's argument, she's arguing she gets a fit parent presumption because of the stipulation she entered into with Father. But that's not what we're at. The stipulation with Father is between two biological parents. It's the fact that she didn't comply with the parenting time provisions because she abandoned the child, she walked away, she just disappeared, that come into play in the step-parent adoption under the totality of the circumstances analysis that the judge used in this case to determine it was in the child's best interest to terminate the rights because mom had abandoned this child. She didn't take advantage of her parental responsibilities. She didn't see this child. She didn't call this child. She just walked away for, now it's been 5 years. So Troxel doesn't come into play in this case at all, as suggested by opposing counsel.
Pardon me for interrupting, counsel. I want to take you back to something that you just told Judge Jones. I had asked Ms. Donnelly whether there was some sort of overarching philosophical reason for treating, importing criminal protections into the dependency and neglect area. And your answer to Judge Jones may have suggested one, and that is that in dependency and neglect cases, somewhat analogously to criminal cases, you have the power of the state arrayed against someone. And in criminal cases, there's a lot of well-established law that says that the power of the state, when it is arrayed against someone, requires significant constitutional protections for the individual. And those include things like the right to counsel. Perhaps, and I'm not saying that I'm of this mind, I'm just struggling here. Perhaps in a dependency and neglect case, you can say something similar because the state is acting. And while the state has obligations to try to render the parent fit, ultimately the state can ask the court to terminate the parent's rights. In other words, the power of the state. In a step-parent adoption case, your position is that the power of the state is not so arrayed against a parent. Am I making a reasonable distinction there or not?
You are. And the distinction really is, it is the step-parent, okay, with the consent of her spouse, in this case, who have been raising this child, who are asserting to the state through the judge that these are the facts of the case, okay? In a dependency and neglect case, it's the Department of Human Services with all of their resources who have provided services, because they have an obligation to do that, who then can say, these services failed. If they've failed, we can't do any more to rehabilitate this parent. Therefore, if we can't rehabilitate the parent, the child cannot be safe. Whereas in a step-parent adoption, the child is safe. He's safe with an intact family that they want recognized legally. So the distinction between the two types of cases is quite large.
Your time has expired, counsel. Judge Bernard, did you have further questions?
I do not, thank you.
Judge Jones?
Thank you very much.
Rebuttal?
To answer your question, Judge Bernard, in Robinson versus People, 173 Colorado 113, the court has acknowledged that we are obliged to address the issues and the merits when it comes to constitutional issues of constitutional proportions. So even if we are not, there's a chance that there's not an agreement that ineffective assistance of counsel would equally apply under step-parental adoption, we still have that case to stand on to address the constitutional issues. They were either raised on direct appeal and should be addressed, or they're going to be addressed because of ineffective assistance of counsel and the fact that the counsel did not raise them. Of course, it is an equal protection problem, and it is a more important problem than a DNN case because of the fact that we are dealing with a fit parent who gets the presumption under Troxel and has not been accused by a state, but we have the same actors, the state, through the General Assembly, enacting two parts of the same statute. One, when we have the allegations of abuse and the state comes under that protection, putting that hat on. The other one, we have a parent who is not accused of anything.
Thank you,
So-
counsel. Your time has expired. We understand that it's been difficult for counsel to get all of the arguments in at this point that you would like to, but I think we have a good grasp on what the issues are in this case. Your briefing has really helped us to do that, and it's not an easy decision for anyone. So thank you very much, counsel, for your briefing and your arguments today. They will help us to make our decision. And it's possible that this is not the last stop for this particular case. So thank you very much. That concludes our oral arguments for today. Your case will stand submitted and a written opinion will issue in due course. The court will